The company which sold you that mobile phone, and let's say that mobile phone is defective, but you cannot go to consumer court because consumer court does not exist and there is no law to protect you as a consumer. So what good is your right related to that mobile phone? Here the government actually suspended the enforcement of all the rights. That should not be the situation. You must know that in which situation which of your rights can be stopped from the enforcement and which cannot be. Articles are Article 13, 359, Article 226 and 32. Article 32 itself is a part of fundamental rights. So why do we need to know about these articles? So Article 13 is, you have seen in many cases, in Keshwanand Bharti's case, where the Honorable Supreme Court laid down the basic structure doctrine, or in Menka Gandhi's case, stating that your personal liberty cannot be curtailed even if you follow the due process of law, the procedure established by law. That process and the procedure must be just, fair. So that has to again pass the Article 14's criteria. So in many cases, you have seen the Supreme Court striking down certain laws, and that's done by virtue of the power given to the concerned Supreme Court or the High Court. The writ jurisdiction, which is the exclusive jurisdiction of the Honorable High Courts as well as the Honorable Supreme Court. We'll keep it really simple with relevant examples. So let's dive into the constitutional remedies. Let's say you have got a mobile phone, but you cannot use it. You cannot use it to make calls. You cannot use it to send text messages. You cannot use it for social media apps. And most important thing is, in case somebody steals that mobile phone away from you, or somebody snatches away that mobile phone away from you, of course, forcibly, you cannot go to police and report and say that this person has committed this illegality to my property, that is my mobile phone, and now you take action. Let's say there was nothing in the law for you to approach the police or any other court for that matter. Another important aspect is the company which sold you that mobile phone, and let's say that mobile phone is defective, but you cannot go to consumer court because consumer court does not exist and there is no law to protect you as a consumer. So what good is your right related to that mobile phone because you deemed it to be your property? So if you have got a property and you have a right related to that property, but you do not have any mechanism to enforce your right, then that right is good for nothing. And that is the most important aspect. And there is a basic principle under the law which says that whenever there is a right, there has to be a remedy to enforce that right, to protect that right. And this is same thing which is applicable to your fundamental rights. So our constitution provides certain fundamental rights to every citizen and sometimes non-citizens as well. So these rights include the right to equality, equal protection of laws, a right to free speech and freedom, liberty, life, and right for religious freedom as well. These fundamental rights which are given there in the part 3 of the constitution, if there was no way to enforce these rights, if there was no way to protect your right, what good are these rights? These rights are good for nothing. So our Constituent Assembly, when they were drafting this part 3 of the constitution, they knew it. When there is a right, there has to be a remedy. So in today's video, we are going to talk about 4 very important articles of the Constitution of India, which relates to the fundamental right and their enforcement. So these articles are Article 13, 359, Article 226 and 32. Article 32 itself is a part of fundamental rights. So why do we need to know about these articles? Is first reason, your fundamental rights are being violated every day by one or this other state government or the executive bodies through the executive orders or some, the universal laws they make, whether it is at the state level or the central level. In all these situations, you have the right to basically enforce your fundamental rights. As we have seen during the emergency period, the government actually suspended the enforcement of all the rights. That should not be the situation. You must know that in which situation, which of your rights can be stopped from the enforcement and which cannot be. And we will also talk about the writ jurisdiction, which is the exclusive jurisdiction of the Honorable High Courts as well as the Honorable Supreme Court, and the kinds of writs that can be issued. We'll keep it really simple with relevant examples. So let's dive into the constitutional remedies. In all these 4 articles, the first and foremost important article is Article 13, which is itself is a part of the fundamental right, the part 3 of the Constitution. and which says that any law which is inconsistent with the part 3, that violates the fundamental rights, basically, that is null and void. So it gives the power to the concerned constitutional courts, especially High Court as well as the Supreme Court, the power of judicial review of any law which is passed by the state or the central government. It also includes certain other ordinances, executive orders, and other things also. So Article 13 itself says that any law which is inconsistent, infringes upon any of the fundamental rights or part 3 of the Constitution, that can be struck down by the constitutional courts. So consider Article 13 as a guard or a sentinel which is there guarding at the gate of the Palace of Rights or the Temple of Rights, Temple of Democracy. So if we consider part 3 of the Constitution as the temple itself, so Article 13 says any law which basically tries to infringe upon the fundamental rights is not allowed to enter into the Temple of Democracy or Temple of Rights, and at the same time gives the power of judicial review to the concerned courts. So Article 13 is, you have seen in many cases, in Keshwanand Bharti's case, where the Honorable Supreme Court laid down the basic structure doctrine, or in Menka Gandhi's case, stating that your personal liberty cannot be curtailed even if you follow the due process of law, the procedure established by law. That process and the procedure must be just, fair. So that has to again pass the Article 14's criteria. So in many cases, you have seen the Supreme Court striking down certain laws, and that's done by virtue of the power given to the concerned Supreme Court or the High Court by virtue of this Article 13 itself. The second article that you must understand is Article 359, which says that in appropriate situations, especially emergency, the enforcement of certain fundamental rights can be stopped by the government. Now, what we have seen during the emergency period in 1975 to 1977, we have seen that the government actually stopped the enforcement of all the fundamental rights. Later on, by amendment, Article 20 and 21 has been, incorporated in Article 359 as an exception, that even during the emergency period, the enforcement of Article 20 and 21 cannot be stopped. Why is that? Is because in case of emergency, let's say somebody is killed by police or illegally detained by police without any case, without any FIR, without there being any offense committed by that person. So, and that person is dead because of the police torture. So what is the remedy available to that person or his family members? So Article 20 and 21, since they basically pertains to your right to life and personal liberty, they cannot be curtailed, and no law can actually stop the enforcement of Article 20 and 21. So at the same time, Article 359 also reminds us the basic essence of law. It says that your fundamental rights are not absolute. In appropriate situation, restrictions can be imposed upon any of the fundamental rights. So although under Part 3 of the Constitution, the fundamental rights are there, their reasonable restrictions can always be imposed in appropriate situations. Now let's move on to the constitutional remedies, basically the writ jurisdiction which is given to the Honorable Supreme Court under Article 32 and Article 226 to the Honorable High Court. Article 32 is a very unique feature and characteristic of our Constitution, because reason being, any citizen whose fundamental right has been violated can directly approach the top Supreme Court in the appropriate situations. What are the appropriate situations? So consider one example, all right? There is one farmer who has been protesting against the illegal acquisition of the land. And let's say that farmer has been illegally, without FIR, detained by the police. And that farmer and his family members are poor. They do not have political connections. They do not have money to actually engage hotshot or top lawyers. So what that farmer and the family members can do? In that situation, the Article 32 is like a golden visa or a golden pass for the family members of that farmer. They can directly approach the Honorable Supreme Court stating, look, this person has been illegally detained by the police, and his personal liberty is a precious right, which is a part of 3 of the Constitution, and that is being violated by the police or the state machinery. Now you take action. So the Supreme Court, which is basically there to guard your fundamental rights, can always issue the appropriate writs. It may be related to Habeas Corpus or the other writ of Mandamus as well in many situations. So this golden visa or the golden pass actually gives the right to every citizen to reach the apex court directly without there being any delay. And the top of the top court, or the Honorable Supreme Court, has been given power to actually safeguard your fundamental rights. So the Article 32 was called the heart and soul of the Constitution by the Dr. Ambedkar, because this is the savior for most of the citizens and any citizen can actually approach the Supreme Court. And you have seen this Article 32 in action whenever the Supreme Court actually deals with the PILs, issues directions to the state and the central government, whether it is related to election or at the time of festivities, related to the pollution, related to the infringement of your fundamental rights of free speech, personal liberty, or your life. In all these situations, your Article 32, which is given to the citizens of India, this is a very important article, and that can be used in most of the situations where any of your right given under Article 32 is being infringed upon. Now, there can be a situation wherein all the citizens cannot come to the Supreme Court, because for most of the state Supreme Court is actually in Delhi, so it is quite far. So Article 226 was incorporated in our constitution, which gives the power to the concerned honorable high courts in case of breach of fundamental rights and the other legal rights also. So by virtue of Article 226, and since it also incorporates the other legal rights along with the fundamental rights, the jurisdiction of honorable high courts is far wider than the honorable Supreme Court. But since most of the people cannot approach and cannot come to Delhi, that's why the high courts have been given this power. Consider these the basic powerhouses in the regional, in your area itself. Wherever your fundamental right or legal right is being violated, you can directly approach the high court. So you can consider the honorable high courts as regional guardians, which are closer, more accessible, and in practical terms, more powerful than the Article 32. And the close reading of Article 32 and 226 make sure that no citizen is far from justice. So to enforce the fundamental rights or the legal rights for that matter, there are 5 kinds of writs which are being issued by the concerned court. So these writs are the basic essence of today's video. The first writ is the Habeas Corpus, second would be the Prohibition, third would be the Certiorari, fourth would be the Mandamus, and fifth would be the Quo Warranto. And these 5 writs can be issued by both constitutional courts. It can be by the Honorable Supreme Court or the Honorable High Courts. Now, this writ of habeas corpus, let's talk about that writ for that matter. This is basically a criminal writ, which actually literally means bring the body. So any person who has been illegally detained, as we talked about the example of the farmer who was protesting against the illegal land acquisition, and if he was illegally detained by the concerned state police, then that family member of that basically farmer, they can approach the concerned high court or even directly to the Supreme Court because of the infringement of Article 21. That is the illegal detention, which basically Article 21 makes sure that your personal liberty and life to be protected. And you cannot be detained without due process of law. If there is no FIR, there is no case against you and the police has actually detained you, that detention itself is wrongful confinement. It is illegal detention. And the concerned High Court or the Supreme Court, they have the concurrent jurisdiction to issue the writ of habeas corpus. Now, second would be the prohibition. Let's say the prohibition means any lower court or tribunal, if they are trying to exceed their jurisdiction, then this writ of prohibition can be issued. For example, let's say tomorrow the family court says that I will be trying the murder cases. I will deal with the murder cases. Now that is not permissible under law. So if this kind of order is being passed that tomorrow onwards we are going to deal with or we are going to adjudicate upon the murder cases in the family courts, in that situation, the concerned High Court or the Supreme Court can always issue the direction of prohibition, basically writ of prohibition. Let's say some illegal order has been passed by the executive bodies or the lower courts or the tribunals. In that situation, by exceeding jurisdiction, if somebody passes this kind of order, then the writ of certiorari comes in play. So the certiorari actually checks the legality of the orders passed. Prohibition was before anything happens, before the jurisdiction is basically exceeded, and certiorari is after the order is passed. That is the basic difference. The fourth writ would be the writ of mandamus, which actually literally means, okay, we command. We command means if there is a duty of any state government, any state body or any central government or any state central department, and they are not doing their duty. For example, let's say you have applied for a birth certificate and it is the duty of the municipal corporation to give you that, to issue that birth certificate, given that you have filed all the documents, but they are not doing it. They are not complying with their duty. Then you can always approach the Honorable High Court under the jurisdiction of 226. wherein the writ of mandamus can be issued, and the Honorable High Court can always say, all right, we command you to do your duty. You do it. You cannot delay it. And the High Court can also issue this direction in a time bound manner that you need to comply with this order in a a span of 15 days, 20 days, 1 month, 3 months, or whatever the time the High Court actually thinks fit. So this mandamus, and you have seen the mandamus in action in most of the PILs where the government is not doing their duty, and the citizen, even a common citizen, goes to the constitutional court and says that this is the duty they are supposed to comply, and they are not doing it. So most of the PIL is basically based on this writ of mandamus. In most situations, the other situations, the habeas corpus as well as this certiorari and prohibition, they also are very important. But in most of the cases, the mandamus is being issued. Now, the fifth writ is the quo warranto. Let's say somebody who is not eligible for a government post, and that person is holding that post. Let's take an example of a vice chancellor. Vice chancellor means a person, let's say, who is also in charge of a university, and law prescribes the eligibility criteria that the appointment of vice chancellor can only be done when that person possesses a degree of PhD or certain years of experience in teaching. And let's say tomorrow a government changes in that state, and they say that this illiterate person must be appointed as vice chancellor because of the political thing and stuff like that. So the issue is, since the post requires certain basic eligibility criteria, and the other person is illegally holding that post, or somebody has got retired but that person is not leaving that post, in that situation the constitutional courts can always issue the writ of quo warranto stating by what authority you are holding this office. So these were the basic 5 writs, and in case of infringement of any of the fundamental rights of the citizens, or sometimes the non-citizens as well, these writs can be issued by the honorable constitutional courts. So again, revising, there are 4 articles which you must remember. Article 13, which the sentinel in front of the gate of or the palace of rights. Article 359, which puts the restriction and empowers the government to actually stop the enforcement of certain fundamental rights. Third, Article 32, which is a part 3 of the Constitution, the golden visa or the golden pass for any citizen to actually approach the Honorable Supreme Court directly and can bring the government and in the litigation before the top court. The second is Article 226, which in practical terms is more powerful than the Article 32 itself. And the 5 kinds of writs: habeas corpus, prohibition, certiorari, and mandamus, and quo warranto. If you have any questions related to it, you can ask me in the comment section. And if my videos actually bring some value to your life, you can subscribe or share these videos with others also. Next time, we'll be discussing some other topic of law, which is very important for every common citizen.